好，感谢大家今天晚上来参加我们的讲座。我们今天晚上讲座的话题呢是房地产投资者必须要懂的法律。这个我们华人的客户当中呢，很多都是房地产的投资者，所以我和 Michael 李律师呢，我们商量了一下，就是今天晚上呢，我们就打算给我们所有的房产投资者，或者说是呢，在以后呢有兴趣做房产投资的朋友呢，做一场讲座。那如果说呢，您这个已经是房产的投资者，或者您将来有兴趣去投资房产的话，那今天呢，你相信今天您一定会得到很多干货啊，我们就会做很多这个干货的法律分享。在这里面我就是先提出的一点是啊，就是虽然我们今天讲的是房产投资者必须要懂的法律，但是有一个法律我们是不会讲的，就是如果说您今天来参加我们讲座的唯一的一个想法就是要听这一方面的话，我觉得可能就是今天可能您就可以省略我们今天的讲座，就是关于 landlord tenant 这个方面，就是我们讲的房东和租客之间的法律问题。那这方面呢，因为是我们事务所本身，我们是绝对不会做这方面的法律的，而且呢有专门的 landlord 和 tenant law 的 attorney，就是或者是 represent landlord，或者是 represent tenant 来去做这方面的法律，所以呢，我们是不做这方面的法律的。那我们今天的讲座呢，也不会去 cover 这个方面。所以在这里面呢，就是先在我们今天讲座的开始，先跟大家讲一下啊这个问题。话不多说，我先自我介绍一下，我是RUI Attorneys 瑞成律师事务所的李小薇律师。我个人呢，主要从事的是遗产信托方面的法律业务，那也帮助过很多很多的客户呢，去制作符合他们个人的家庭的情况的遗产信托规划。我们在线上的另外一位律师 Michael Lee 律师呢，相信大家很多的朋友都很熟悉了，因为今天同样参加我们讲座的还有已经是我们客户的很多的朋友啊。现在我请 Michael 律师做一下自我介绍。Michael, can you introduce yourself?
Oh, greetings all. It's good to be here for our another monthly installment. So we have some good stuff planned. As you know, Mike Lee, I'm a partner of the law firm, founded the law firm, have worked in a variety of areas, most notably the U.S. Attorney's Office and the Internal Revenue Service. Great place to work. I miss them. I miss them very much. But private practice has been even more fun. So look forward to having an enjoyable session with you all tonight.
Great, great, thank you. 所以呢，我们每个月讲座，了解我们的朋友都知道啊，我们每个月都会给大家做一次讲座。在我们讲座的一开始呢，我们会花一点时间，把我们认为在这一个月当中，我们 practice 过程当中，或者说在新闻头条里面，和我们 practice 相关的比较有意思的一些事情跟大家分享。那今天呢，我们想跟大家分享的是什么呢？就是sorry，就是这个是我们的目录啊，就今天我们大概会 cover 的内容，在我分享之前先说一下，就是大家可以看一下，我们主要会 cover 一些就是典型的以什么样的 title 的形式来持有房地产，以及如何用 LLC 来持有房地产，以及房产上面有哪些税务大家需要考虑的。那最后呢，我们也会讲一下，在给房地产做遗产信托规划的时候有哪些需要注意的事项，这是我们今天的 roadmap。好，那首先呢，我来讲一下，这次我们这个月我们想跟大家分享的一个是什么呢？就是说，在我们做这个遗产信托规划当中，有一个特别重要的一个主题，但是往往会被很多的客户，也会被很多的律师所忽略的一个方面呢，就是你的个人的资产的部分。就是像比如说有一些就是对于大多数人来说非常常见的资产，比如说我们今天讲的这个房产。然后包括像银行账户啊，你的股票账户，包括像一些人寿保险、年金等等的一些金融资产 （financial accounts），可能大家都会就是在一说到规划的时候，都会首当其冲的就会想到说我要去规划这些资产。但是实际上呢，在我们做遗产规划当中，还有一个很重要的一个部分。当然呢，就是这个部分对于有一些人来说的话，会被另外一些人会重要，因为有一些客户他就会拥有一些价值比较多的这方面的资产，这就是我们所讲的 personal property，中文呢我们叫做个人资产。那典型的个人资产有哪些呢？比如说你的车、你的船、你的身上的衣服、你的家具、珠宝、手表。 然后以及像枪械，或者说比较值钱一点的像艺术收藏品、古玩，包括像宠物、红酒这些。那这些personal property 呢，都是我们在 practice 当中去处理过的，帮助客户去解决、去处理过的一些个人资产，在他们的遗产信托规划当中。那对于有一些客户来讲呢，那这部分的资产可能并不是他们的资产的很大的一部分。你比如说，有的客户的话，他就是对买房子有兴趣，那他吃穿用都非常的简朴，他也不喝酒，也不会去买珠宝，也没有什么就是所谓的名贵的这些手表啊，然后衣物这些，那可能你就不需要去做太多的这方面的规划，那我们就做一个 general 的一个 provision 就可以了。但是大多数人可能就是有船的人可能还是少，但是有车的人还是比较多。那车呢，可能要经过一个简单的过户跟 DMV 啊这样的，就是去处理是比较。相对来讲比较简单的，但是对于有一些客户来讲的话，如果说你有比较 significant 的 personal asset 的话，那你就需要注意了，在你的遗产信托规划当中，你一定要考虑到这方面的问题。为什么呢？因为就是我们经常遇到的一个情况，今天就是在我们讲座前，我还跟 Michael 律师我们有商量过，就是有讲过一个就是这个我们身边的一个案例哈，就是这个有的有一个老人他去世了，去世的时候他其实身边有很多的，就是因为他们是以前就是大概是很多很多年以前经历过很多美国的一些非常有历史性的一些event 的，像退役的军人啊这样的这个家庭。那所以呢，他们可能会有一些历史性的一些纪念品啊这一些，但是因为在他的 estate plan 里面，他没有去做很多的规划，然后再加上周围的亲友也不是特别了解，那最后呢，他们发现其实很多的这种很值钱的、有一些纪念价值的这些 personal property 呢，最后都被他的 caretaker 就照顾他的人给拿走了，所以其实是一个就是挺不幸的一个事件啊。那更何况呢，有很多的像 personal property，实际上它除了有一些经济价值之外，其实更重要的是有一些我们叫 emotional 或者 sentimental value，就是有一些情感价值在的。你比如说，我们最常去处理的一类，像珠宝类的，那如果说这个 piece of jewelry 是你的妈妈的，你的他非常珍爱的，他经常就是会戴的这个珠宝，那他又有可能两个或者两个以上的小孩，那这个珠宝到底是给谁呢？有的时候可能这个东西本身并不是一个很值钱的东西，但是对于小孩来讲的话，可能更多的是就是这个代表的是就是我对我妈妈的感情。那如果是你 potentially 有这样的一个问题的话，那你可能在你的 estate plan 里面，你就要想一下说，OK，那我这个珠宝应该怎么去处理？就简单的给大家举一下例子。那我相信呢，Michael Lee 律师那边呢，他也有两个例子想要就是跟我们分享一下啊，他的真实的案例。那我们请 Michael 来 share 一下your examples。
Just a few examples, because this is, interestingly enough, a little bit of a complicated area of planning, and it reminds me of an Irish expression that uh, says when you don't look at property, or like you don't look at things, they grow legs. And it basically means if you're not watching something, it's potentially can get stolen. And this is something actually to think about with regard to personal property is the physical custody of some of this property. So this is something to think about. Again, a boat, maybe not, but actually a boat, you have to think about if it does it have slip fees? Are you storing it somewhere? Who's paying for that? Because that can be a problem if you go into arrears, particularly for a boat. If it's on salt water, if you don't pay the slip fees, they can sell the boat to pay the slip fees. The bigger thing that is that I'm having and encountering with clients now, partly because of the world economy, is gold. Clients are mentioning, they're saying, actually, I have gold coins or bars. I had a client that said, I have an actual gold bar, and I thought it was a 1 kilo bar. I said, no, no, no. It's the late 19s or the early 1900s. The New York Mint Gold Bar is 27 pounds. So 27 pounds. It's like $400,000 of gold. It's like, yeah, caretaker might wander off with that thing, for $500,000 that I could very heavily kind of carry away. So thinking about physical custody of the assets. So if you have things like this, like jewelry, gold, thinking through the physical custody of these things as one gets older, where is it? Where is someone actually going to find this thing? Is it secure? Because again, if it's not watched, sometimes things can grow legs. The other thing is, do you have a property, 3 classes of property offhand that have transfer restrictions or the ways that it's sold? So if you collect this sort of thing, you may have to think about, is my next generation well suited to deal with it? Number one, real story wine, a very touching experience of mine. I was very different case than what I deal with trusted estates and tax. It was a bankruptcy case. The case was Premier Cru Wine. We represented a large creditor. There was all kinds of fighting because there was thousands of bottles of wine, but it had all been oversold and everybody was fighting about it. And the case was being mediated by the premier judge, PG&E judge, Judge Montali, and he's about 70 years old. And he was just talking about his experience dealing with this thing. His father, their Italian-American family, passed away, and his father had a huge collection of wine from all over the world that he had collected. And in addition to lots of wine that he himself, his father, had made. His father used to make grappa, the distilled Italian liquor and everything. And he told the story that actually, to sell wine, which is true, if you have a huge lot of it, if you sell it by consignment, you give it to a store to consign, they take a very, very high fee, like an auction house fee. And unlike an auction house where there's an auction house premium, so the buyer pays the auction house fee, a lot of consignment sellers, you, the seller, pay the consignment fee. You basically a third or sometimes half of the proceeds go to the consignee. So this was not appealing for Judge Montali. He said, well, I'll just sell the wine myself. I'll just, put an ad, I'll just sell it myself. No. You can't sell alcohol without an ABC license in California, an alcohol beverage control license. So, of course, being an extremely skilled lawyer as he was, he went to the ABC and he got the license and posted in his law office the notice of intent to sell alcoholic beverages wholesale and did the whole thing. And the reason I mentioned is, of course, it tells this story of you have a particular way to sell this. Of course, he avoided the premium, but had to do all of the work. Is complicated. And then it was also a touching story that even at 70 years and the premier judge mediating this case, he still had he got emotional telling the story. They still had the love of his father, even though he was a 70-year-old man who had become probably one of the most respected, the 20 most respected people in the Bay Area, was still actually a little boy with his father. And he still had that memory, which is very touching. But on that side, the emotional side, there's that, but there's also the practical side. Some things are difficult to sell. Another thing that I encounter to a surprising frequency in Northern California, guns. Guns cannot be transferred easily after the death of a person without the involvement of a federal firearms licensee. You have to have someone with a federal firearms license. You have to go through a very elaborate process of who's going to get this firearm, depending on the situation. This is unlikely, but every once in a while it happens. The person you name as the beneficiary, if they have a felony conviction, they are not allowed to receive this property. So if you have something, again, alcohol, highly regulated, guns, highly regulated, you have to think through that in your estate plan. The last one was a really weird twist of a story that I've encountered in my practice. And this one was a super curveball. It is a client that had a set of Japanese swords. And they were Japanese, they were for lack of a better term, I'm not a sword expert. They were like a Japanese samurai sword. Expert dated them to around the Bushido period, the samurai period. They were the true samurai swords. They were obtained from the family during World War II. It was an American family, and they were the victors' war trophies. The family said, that was kind of crazy, grandpa's war stuff. We want to sell that stuff because it's creepy, and we don't like we don't really want these like swords around. Let's sell them. We said, okay, they look good. The appraiser says they're worth, and by value, in the 6 figures of value. Took them to a very well-known auction house. Likely you all have heard. They looked at them and said, oh yeah, I know exactly what these are. They are the Bushido era, the Tokugawa era samurai swords. That we're okay with. What was the history of your grandfather? Okay, he was stationed here, he was stationed there, and they were captured from the Japanese military. What year? 45? Yeah, and what was that unit there was? It was the Manchurian unit. These were probably used in Nanjing. They probably have a cloud on them. We won't touch them. It's like Nazi memorabilia. We won't sell this item. It is a samurai sword, but the cloud of what may have happened to these during World War II, we can't sell them. So kind of a major blow is that when we found this with actually a few of the auction houses, that they would not sell this product because it was sort of like saying, oh, I have Hitler's hat. And it's like, yeah, no, we're not going to sell Hitler's hat. It's something that's, we don't want to touch this item. So 3 things is, again, alcohol, guns, or if there's some historical provenance to the item. Last thing this can happen to is art. Is another one. That one was a sword or a set of swords, but art. What's the provenance of the art? How did you get this thing? Can be something. So dealing with personal property, it comes up in estate planning. Things to think about are, again, transfer restrictions, and then again, physical custody of the property. The other thing is also just one last thing, as Xiaowei has, we have listed here, that this reminds me of another item we'll never forget. Bronze cat with patina was how it was described. Some items have sentimental value, and this happens much more than, nobody cares about stock. No one's going to say, I have to have the IBM stock. I have a sentimental value. They just say, how much is it worth? Okay, I'll take that. People care about, apparently, bronze cat with patina. Why? Because mom loved it, and I want it. And I also don't want my sister to have it. And that can cause a lot of trouble if you have this. We've encountered this many, many times of items with let's say, bronze cat with patina. Family insisted it get appraised. They couldn't agree on appraisers. So we had 3 because they couldn't agree. 3 appraisers, unanimous consent, bronze cat with patina is worth 0. Not even worth to melt it down for the bronze, because apparently the bronze was of such low quality, you couldn't even sell it for scrap, because the bronze was all adulterated with other alloys. You couldn't even melt it down. It was worth nothing. It was a trinket that used to be given away in the 1970s when you bought gas, apparently. But family fought over it. So thinking about things also that will cause, again, good estate planning, reduce conflict. If people are going to fight over something, try to get ahead of that. I tell this story a lot because we got into the Trusted Estates Journal for this tactic of using a dice and using random selection. Had an Indian family. They were a very well-to-do Indian family. They loved jewelry. They loved gold jewelry. They also loved their children, of which they had 6, and they also had all girls. That was going to cause some conflict because you had a lot of jewelry and you had sentimentality for some pieces and you had value for other pieces. So we came up with a system of drawing lots and doing a dice, and you do by rounds, and you pick and you pull and you organize the jewelry. But throwing that out there is just some fun ideas for thinking through is, let's try to solve conflict. Let's try to see the conflict ahead of time. Is this something people are going to fight over? Is it something difficult to transfer? Is it something that's going to be difficult to sell? Is it something that's going to walk away? Let's figure this out because there is a great interest in this personal property. It can be very, very important. And sometimes estate planning just says, the personal property, we'll just divide it up. We could easily say, let's just divide the cash up. Cash divides really easily to the 10th of a cent. We can do that really easily. We can't divide up bronze cat with patina. So that's something to work through with your estate plan because it will prevent conflict and make things easier.
好的，感谢 Michael 刚才的分享啊。总结一下就是几点，一个是就是你要确定，如果是 personal property 的话，它和 financial account 不一样，它是有一些机构保管的。personal property 在这个人生前的话，可能就是在这个人的他自己的保管之下。那你需要去考虑的一个问题就是怎么去掌握这个 personal property 的 physical custody，怎么去处理在这个 estate planning 里面。然后另外呢，有一些 special assets，比如说像酒类，或者像武器，像这个枪支类。那 Michael 还举了一个例子，就是日本的这个军刀，如果说有一些这个历史性的一些问题的话，怎么去处理，可能是需要一些特殊的 special 的一些处理的方法。那还有呢，就是像艺术品、收藏品之类的，这都是我们需要去特别的去 address，特别的去注意的。那其实呢，在这里就是要提醒大家一下，如果说你的 estate 里面，你知道有一些个人的。个人的 property，不管是因为它的，比如说经济价值特别高，还是因为你觉得说是它有一些对你的家庭来说有一些 sentimental value，或者说有一些 emotional value，你知道可能在你身后的话，如果处理不好，会引起家庭的一些不和谐的地方，或者有一些矛盾的地方，那你就需要特别的在你的遗产信托的规划的文件当中呢，要想清楚。有的时候呢，你可能有这个 idea，有这个问题的时候，可能最好的一种方式是来跟我们专业的律师来一起聊一下，那可能呢我们可以给你出主意，然后看一下怎么样去做一个规划会更好。好的，那接下来呢，我们就进入我们今天所讲的这个关于房地产的问题。讲完了个人的资产，那我们接下来呢就讲一下这个我们大家最关心的，我们华人的朋友们最关心的房地产的问题。那么在一个房产上面有哪些的 title 的形式，你可以用哪些title 形式来去持有呢？其实这个话题我们以前有做过相关的一些讲座，也有给大家介绍过很多次，所以在这里面其实就是相当于把我们以前给大家讲的一些内容再重新的跟大家再分享一下啊。首先呢，就是最简单的一种 title 的形式，我们叫 sole ownership。那这种呢，当然就是最简单。我们在这里面有给大家举个例子，大家可以看到，就是比如说Michael，sorry Michael，use you as an example。Michael，a single man。那这个呢，就是最典型的一个这个
I like
single。
this example because I'm all alive in all of these. I don't like to be the testator.
Yeah，所以呢，在这里面我们这个就是在经常我们的这个deed 的上面呢，你就会看到Michael a single man，那这就是最典型的一个 sole ownership 的title 持有形式。那接下来的这个呢tenancy in common 呢，其实也是蛮常见的，因为这个最常见的就是我看到有几个家人或者是朋友一起来买房子。那如果是这种情况呢，有很多的朋友会使用这种 tenancy in common，甚至有一些朋友都不知道自己这个持有资产的形式是 tenancy in common，因为一般来讲，在 trust 在你的 deed 上面可能也并没有显示 tenancy in common 这个词，只是显示了，比如说这里面举的例子 Michael and Sam，没有显示其他的一些特征。那这个时候呢，基本上你的这个 title 的形式就是tenancy in common 的形式。那要讲的是什么呢？就是如果说是 tenants in common 的这种形式，我不知道大家有没有注意，就是这种 ownership 的话，一般来讲，就是可以是双方的比例是不一样的嘛，持有的比例是不一样的嘛。如果说你以前买过房的话，可能你都会经历过，就是比如说我们这个我们这个案例里面给大家写的这个 Michael and Sam，很多的情况是没有写比例这样的一个情况。如果说没有写比例的话，它的 default 就是说这两个人是各自持有这个房产的50%，就各自持有这个房子的一半。那有的情况下呢，我们也会看到，就是它在 title 上面会写比例，就是在 tenancy in common 的这种 title 形式，它是允许两个人或者两个以上的人是持有不同的比例的。那 obvious 的呢，这种方式来持有房产，包括我们上面讲的，如果说是sole ownership，Michael a single man 的这种形式来去持有房产的话，它都会有一个 以前我们也有给大家讲过，都会有一个就是如果说人去世了的话，那会有 probate 遗产认证的问题。如果说你不把它放到一个架构当中去的话，那整个如果是一个人持有房产的话，那整个这个房子就要去做一个 probate，在这个 probate 的法庭的遗产认证程序当中，就要去analyze 它的继承是怎样的。那有一些情况下的话，虽然写了是一个人的名字，但是并不代表是这个一个人的个人的资产。如果说两个人是结婚，就是这个人是在去世前是已婚的这个状态下，所以呢，又会增添一些复杂性。那如果是 tenancy in common 的这个情况，只要有一个人去世的情况下，那他的这个部分就要经过 probate 遗产认证的整个的 process，然后才能确定去世的这个人他的继承人是谁，然后现在谁有权利可以继承到他的份额。那有的时候呢，我们会处理的案例就是说，在 tenancy in common 这个情况下，两个人都没有做一些规划的情况下，有一个人突发意外去世，那如果这个人他的家庭的结构又比较复杂，有一些纠纷的话，那如果这个房子要比如说要 refinance 或者要卖，或者要做一些交易这些的话，基本上另外一个人就 stuck 在那边，不可以去做任何的事情，要一定等到整个的法庭的程序结束，有的时候可能是1年、2年，甚至更长时间才可以对房子呢去做任何的事情。那这无疑呢就造成了整个的就是你的这个就停滞在那里面，给你会造成很多很多，不管是经济方面的，还是这个其他生活上的一些不便啊。那还有一个问题呢，对于这两种就是 sole ownership 和 tenancy in common 的一个很大的问题就是，如果说有一个人。那一个人的话，那当然是如果你有 creditor，你有债权人的话，那债权人肯定可以去 collect 你的整个的房子的它的份额。但是如果是 tenancy in common 的这种情况下，你和另外一个人一起持有的话，如果一个人有 creditor，比如说一个人他有一些民事诉讼、民事纠纷，然后法院判定说 OK 他欠债了，或者说他有一个 accident，那他 insurance 没有办法去 cover 他的 liability。那另外一方要在他的这个房子上面去加 lien，就是我们说的质押权这些的话，那 obviously 就会影响到这个房子的产权。那你这个房子在做任何的事情，基本上就非常非常的困难，除非你可以把这个 lien 给remove 掉，所以就会有一系列的问题。如果是以这样的 tenancy in common 的这种形式来去持有。接下来呢，在讲的这个 joint tenants 呢，也是一个特别常见的两个或者两个以上人持有的房产的形式。我们在这里面呢，给大家举的例子是，大家可以看到，如果你的deed 上面写的是 Michael and Sam as joint tenants。那一般来讲呢，它就是 joint tenants。有的时候呢，你还会看到一个字叫做 with survivorship。在加州呢，基本上如果是 joint tenants，即使没有 with survivorship 的话，它的基本的情况也是就是会有 survivorship。这个 survivorship 在这个里面的意思是什么呢？主要的意思就是说，这个房子如果在一个人过世的情况下，那剩下的在 title 上面的人，他会有这个房子的全部。那直到我们叫的 last man standing，就是最后一个人，他会持有这个房产的全部。所以假设说，如果比如说 Michael 在这个情况下，他做了自己的一个estate plan，然后他在自己的 estate plan 里面没有指定 Sam 去做他的遗产和财产的继承人。那在这种情况下，比如说他指定了他的小孩来去做继承人，但是如果说这个房子它的 title 是 Michael and Sam as joint tenants 的话，那在这种情况下，他的 estate plan 是没有任何的用处的。那如果说 something happened to Michael，那 Sam 呢会得到整个的这个房产。当然，我举的就是一个可能是 最简单的一个例子了啊，但是还有一些实践过程当中还有一些更复杂的一些情况。那如果是 joint tenants 的情况呢，一般来讲的话，每一个人在房子上的份额呢都是相同的，就 Michael and Sam 都是50%。一般来讲，它不允许你像 tenants in common，每个人可以持有不同的份额，每个人呢是有相同的权利的。joint tenants 呢，同样也有刚才我讲的，对于 sole ownership 和 tenants in common 都有的 creditor 的问题。如果说有一个人，比如说被告了，或者遭遇一些这个诉讼啊，这些情况的话，那如果说是这样的一些情况，那在这些情况下，同样你的 creditor 一个人的 creditor 可以在这个房子上面添加质押权，从而影响这个房子的它的交易。OK，那接下来呢，我们过渡到joint tenants 之后，我们就过渡到了两种持有房产的方式，但是这两种持有房产的方式基本上只有是发生在夫妻之间才去使用的方式。一种呢就是 community property，比如说 Michael and Wanda as community property，那另外一种呢是 community property with survivorship。比如说 Michael and Wanda as community property with survivorship，这里面为什么要一定把with survivorship 和 without survivorship 没有这两个字这个单独拿出来跟大家讲呢？就是我们在实践过程当中，其实遇到过很多的 case，出现了一个什么情况呢？就是在这种情况下，客户是以 community property 形式来去持有房产，但是后面没有 with survivorship 的这两个字。如果说没有 survivorship 的话，如果比如说 something happened to Michael 发生了任何意外的情况下的话，Wanda 是不可以直接的去继承这个房产的。虽然它上面写的是 community property，虽然你认为说 Wanda 既然是他们两个人 community property，加州的 community property law 不是说这个是夫妻两个人共有的财产，应该就是我的吗？答案是不是的啊。with 和 without survivorship 这个字非常非常的重要。without survivorship 的话，那 Wanda 就需要经过整个的法庭的程序，才可以才可以让法庭来判定他这个房产到底是谁的。如果是 with survivorship 的话呢，一般来讲，Wanda 是可以拿到这个房产的全部。If something happened to Michael，所以大家可以看到，就是在我们买房的时候，经常因为我们给客户做遗产规划，最重要的其实一个环节就是去问客户说，你知道你的房子现在它的 title 是什么吗？当然，你如果不知道也没关系，我们有方法可以帮你拿到。但是，一般我们都会大概问一下客户。但是我可以说，大概有一半以上的客户，我们问到这个问题的时候，他们会讲说，其实我也不知道，因为我们当时买房的时候，没有人问过我们，就是要以什么样的 title 形式来去持有，然后可能就是看我们是夫妻两个人，就帮我们选了一个，或者说，这个就是当然也有一些情况下，这个客户被问到了这些问题，但是客户可能也没有去问专业的律师，然后去拿这些专业的意见，可能就是随便选了一下，可能看了一个选项就选了一下。但是这里面我就是要跟大家强调的是什么？就是其实你可以看到啊，等一下 Michael 律师也会给大家举几个例子，就是大家可以看到，其实在现实生活当中。title 实在是太重要了，你的 title 可能哪怕只是差一个字、差两个字，它的差别都是非常非常大的。那最后呢，我还就是想给大家介绍两种 title 的形式，就是我们可能更推荐大家去持有房产的 title 的形式。那一种呢，就是以信托的形式。那这个信托呢，当然又分为可撤销生前信托和不可撤销生前信托。大部分的信托呢都是可撤销生前信托。当然呢，因为一些这个，比如说资产保护，或者说因为一些遗产税规划的情况呢，有可能我们会给客户建议的是不可撤销信托。但是呢，我们一再跟客户讲的是，就是你不要以为不可撤销信托就是随随便便可以去 去建立的。因为很多人就讲说，如果说不可撤销信托有资产保护作用，为什么我还要去建可撤销生前信托呢？就是因为不可撤销信托是有一些你要去 trade off 的一些点的。你比如说，如果说你的房子，可能我们大概80%的人买房都是需要贷款，有20%的这个呃人可能不需要。那 all cash 去买，那如果你要有贷款的话，你可能就无法去设立一个不可撤销信托去持有这个房子，就有各种各样的原因。另外，你如果是不可撤销信托，你可能在管理和控制方面又有一些特殊的要求。但是 in any case，我觉得 at the minimum，我们所有人都需要去考虑的就是以一个可撤销生前信托来去持有你的房产，这样呢可以规避掉所有的 probate 的问题。那同时呢，你的资产在你比如说失去意识行为能力的情况，哪怕没有去世的情况，那也可以得到妥善的一个安排和处理。那最后一种呢，也是等一下我们会花一点时间给大家讲的，就是以 business entity LLC 或者 corporation 的形式来去持有房产。那实践当中，就是大家可能会讲的说，啊，那 LLC 我们看到的情况挺多的，就是这个以 LLC 来持有房产，但是 corporation 真的有人会用 corporation 吗？答案是在有一些特殊的情况下，我们也会推荐客户以 corporation 来去持有房产。当然都是一些就是极特殊、极特殊的原因，可能大部分的情况下呢，我们还是选择用LLC 来去持有尤其是投资房产的房产。这里面特别要跟大家讲的，投资房和自住房，因为在法律和税务上有很多的区别和差别，所以呢，在很多情况下，它的处理呢是完全不一样的啊。所以就是这个里面也要就是有一些具体的划分。那这里面我们讲的就是一些情况下投资房需要考虑LC 的这个情况，我们基本上是把它限定在投资房。如果是自住房的话，就会有一些其他的特殊的不同的一些考量，可能 LC 呢并不是一个非常好的选择。OK，那我就大概花了一点时间给大家做了一个非常，因为也是这个每次讲座我们都觉得时间过得特别快啊，就给大家做了一个快速的讲解。那现在呢，我们想请 Michael 律师，看一下 Michael 律师那边关于我刚才讲的这些 point 有没有一些补充的地方，或者在实际应用当中 application 有哪些大家就是你看到的案例当中，尤其华人朋友们有哪些需要特别去注意的一些地方。
Just a few. These are ripped from our practice books here that we've encountered, and some kind of odd problems. But when you have these problems, they can be really massive problems. Oftentimes, the problem is something obvious, but again, as lawyers, you never know what's going to come through your door. First one, community property or community property with survivorship. You must be a married couple, husband or wife, man and man, wife and wife, whatever, but you must be a married couple. I've encountered, again, doing this for 15 years or so, every once in a while, I'll see titling that is, X and Y community property. I'll say, who's that other person? I'll say, oh, it's my mother. It's my father. I said, how did this happen? I'll tell you how this sometimes happens. One of the big problems is, and it's a lack of familiarity with the culture. Western people are not familiar with Asian names, and they can't tell. John and Bill Smith can't possibly be a married couple. Because we'd say John and Bill, and actually I can tell you the same. You say can't possibly be a married couple. Possibly a married couple. Could be. You got to ask questions. So the problem is, I've encountered this where sometimes the title company or somehow it happens that you can't tell the names easily, and there will be titling as community property. And if you are not a married couple, that causes basically the title escrow officer hit the roof when you try to sell, because this is a major titling, they call it a call, major call problem. And it can be especially problematic if the people are friends. And this is a really one of the situations that we had. There was a problem with this, is that some states, like Iowa, have common law marriage. And they say, I think John and Jim are married. And you say, no, they're just, friends. And they say, well, I don't know, if they were ever in Iowa and they were together a lot, maybe they're married. Iowa says that they are, and we, because of the Constitution, we respect other states' marriage procedures. So if they live there and then they came here and it says community property, maybe they're married. It causes a just huge problem if you basically use the wrong one. So community property have to be married. It is the preferred way to hold when you are married in California. Why? Because of the double step up in basis. So if you are a married couple, we often recommend to our clients, if you're joint, switch to community. Why? You'll avoid trouble with the IRS arguing about the double step up in basis. So that's good. If you're a married couple and you hold as tenants in common, you definitely got to change that. The majority of my probate cases or Hegstead cases, basically having to file a petition to bring the asset into the trust or having to fully probate it, is because somewhere there was a tenants in common deed. And most title companies, and I'm dealing with this just recently, most title companies, when there's a joint tenancy or even community property without survivorship, if the property is not very valuable, maybe they'll let it slide and that they won't require a community property petition or a Hegstead. But tenants in common, they'll always require it because the deed mandates it. It says, this person and that person each own their own share autonomously. There's none of this survivorship issue that you see with community property with survivorship or joint tenants. So be careful with the tenants in common deed. Other thing, moving on, and I see this a lot with people doing their own trusts or people trying to fund their own trusts, the trust deed. It must be Michael Lee as trustee of the ABC Trust. If I say Michael Lee grants to the ABC Trust, just starting this year, most title companies will not take that and will demand a Hegstead petition. Why? Is because a trust is not a legal entity. A trust is a relation of property to a trustee. The person is essential. And so the trust is essentially a grant. How does a trust come about? It comes up if I say, I, Michael Lee, own, well, you can't see the pen. I, Michael Lee, own this pen, and I transfer it to John Smith as trustee pursuant to the trust agreement. There's a transfer. And when that property goes from my hand to his hand and continues on, that property is encumbered with the deed of the deed is encumbered with the trust, with the terms of the trust. So there has to be a person. If you say ABC Trust, like an LLC or a corporation, that is a legally different concept than a trust. So this is like the core fundamentals of law, and that a trust is not an entity. A trust is a relationship to property. So dealing with cases this year, spoke to the kind of the title gurus, First American, Chicago, even Orange Coast, which usually insures anything. They say if there's no trustee, they're not going to insure it anymore. They're going to mandate a Hegstead. Why? Recently, a few title companies have really gotten burned with this. Is that they insured a sale and then someone came out of the woodwork and said that person wasn't the trustee, and then they said, we really probably should have mapped the chain better, and they got on the hook. So be very careful doing your own trust transfer deeds or doing like some hokey, like throw it together trust, because that deed is going to be the critical thing. And if you do the trust, and then the title company won't accept it, you have a big problem. So
Michael, I just want to add this one point. 所以地的可能是我们见到的所有的法律文件。如果您跟我们办公室去做文件，你可能觉得这个地的这个文件应该是你见过的最简单的一个文件，就是也是最短的一个文件。但是地的其实是非常非常重要的一个文件，在美国的它的法律当中，在房地产 它的不管是遗产继承啊，还是这个房地产交易啊等等，这个都是非常讲究整个 trust deed 它的 title、它的格式、它的形式的，千万不要小看 deed，虽然它只有一页纸，但是有的时候是2页啊。但是这个 deed 上面的信息虽然少，但是每一条都非常的重要。这真的是 require 你在 draft 这个 transfer deed 的时候要非常非常的注意和小心，否则的话，如果你犯了一个错误，有可能呢就会导致以后有很多很多的以后的问题，包括 chain of title，包括 probate 等等这些问题存在。
Yes. So that's what be be very, very careful with that trust transfer deed, because the name of the trust, even though I often use this example, the box of the trust, and I generally use a caveat. They say this is a good way to think about it. This is a metaphor to think about it, but it's the wrong legal description. It is the wrong legal description. What the accurate legal description is that actually the trust is an encumbrance upon the property, that because encumbrances on property run with the land, the encumbrance runs with the land. The problem is that's really hard to understand, so we never talk about it that way. But with regard to a trust, that is the way that it works. So use professionals to do the deed, because this can really be a major mess up if that happens. The other thing which can really help on deeds, if you do a deed to a company, an LLC or a corporation, use the correct titling. Sometimes we even use ABC, a California limited liability company. And I've even on some of them say ABC, a California limited liability company, brackets, Cal SOS, C1785762. Why? Because I want this to link up with the company record. I've had this before. People say, and people will do it with LLCs and things. Or I've had this actually. It was more with I do have some clients that use foreign entities because they're foreign people, and you just say Twin Oaks Ventures. It's like, and then they say, oh yeah, this thing's from Bermuda. Again, a U.S. title company says, what? It just says Twin Oaks Ventures. It doesn't say anything on here as to like what kind of a company it is, what country it's in, how do I identify this? And again, why is this important? Title insurance, when you go to sell the property, the title insurance says that guy signing the deed to the buyer, that guy's the right guy, and I back it with my money. And so when they say, oh, too weird, strange, this is going to blow up in my face, and then they're going to ask me for the $5 million, you really don't want a situation where the title company says, I'm out, too dangerous, I'm going to get sued, don't want to touch it. Because again, title insurance, if you bought and sold a house, it's a few $1,000s. They say, why am I going to risk $10 million, $5 million for a house for a $5,000 or $10,000 title insurance policy? I'm stupid to do that. Unless it's crystal clear, I don't want to do it. It's not enough money. So be careful with these deeds as well, because if it's not clear, it can be a big problem. Actually, I'll say this is about real estate, but let me just tell the story of the client abroad, titled the brokerage accounts in the distant families. In basically, we had a client, they used limited liability companies to hold brokerage accounts. They kept bad company records. And they basically used a lot of these like nominees and like kind of like straw men to be the manager and members of the companies. And the brokerage company basically just said, this all looks like fraud. We're just going to tell basically the comptroller of the currency and the SEC, we're going to lock down the account and you go to a federal court and sort it out. Had several $1 million in there. And this can be something, again, on the other side of when you do use trusts or you use business entities, you have to keep good records, because this is supposed to bookend. The purchase goes into the LLC documents match the purchaser, the records are kept well, and then 50 years later, when we sell, and then the new person says, I'm the seller, the records should all line up. And if the records don't line up or the records are gone, again, when you're asking the title company to back this with their own money, or again, not real estate, but it's, let's say, a brokerage firm, and it's a lot of money, and they say, oh, we have all these different people's names on here, and then nobody can notarize anything, and you say some people are dead, and this is all a mess. They just say, you know what, go to court. If the court orders me to do something, I'll go do it. But until then, I get the commission either way, holding the account. So I'm just going to keep taking the commission, and you can tell me when to transfer it later. So be careful. That was actually I just encountered that case about 3 weeks ago.
好的，就是感谢 Michael 刚才的分享，所以其实也讲了我们接下来要讲的一部分的内容，就是很自然的就引出了我们今天就是也是我们的客户当中，其实大家问题最多的一个，就是说我现在要购买投资房，或者说我现在的房子已经买了，但是我是不是需要把这个房子 transfer 到一个 LLC 里面，然后我做一个 LLC， 把这个房子放到 LLC 的架构里面。那这里面呢，就是说，刚才当然我在一开始也讲了，就是说，首先就是你要去identify 的，就是这个房子到底它的用途是什么，就是到底是你的 primary residence 还是就是用于 collect rent 的一个 investment property，因为这个房子 primary residence 和 investment property 是有截然不同的一些法律和税务上的规定的。所以我们现在就把它局限在，就是说，如果是你只是购买房子去进行投资，那这里面呢又分成，就是这个问题也是很重要的，就是说也要分这个房子的性质是什么，就是因为我们大家投资房产都知道，房子分 residential 分 commercial，那 residential 里面又分说。到底是低于4个 unit 的，还是超过4个 unit 的？因为如果是低于4个 unit 的4个 unit 或以下的话，它就是一般的正常的 residential。但是如果说是超过4个 unit 的话，可能在一般情况下，我们就把它做成 multi-family commercial 的一些它可能更趋向于一些性质，更趋向于 commercial 这样的一种形式来去对待啊。那如果说是以 LLC 来持有房产的话，它有哪些的优势呢？首先就是说，我觉得为什么很多人不呃不会考虑像以一些 corporate 的这种形式来去持有。一方面就是说 LLC 呢，它本身虽然它是一个我们叫它 business entity，但实际上呢，在法律上它是一个我们叫一个非常 special 的一个 entity，它本身是没有那么去 strict 在formality 方面。所以呢，有很多的相对于一般的，比如说我们真的是去开一个 corporation，这一类的 business entity，这种情况呢，其实是有，相对来讲就是要简单很多。它的不管是从 legal formality 角度，还是从文件的角度，但是，你必须你的 LC，如果说你打算要以LC 来去持有房产的话。我这里面一再强调，因为我们见过太多了，包括我们 record deed 的时候，有一些 county 需要的客户的这个 LC 的一个核心的文件就是 LC 的运作协议，但是很多客户 DIY LC，包括有的时候找这个会计师来去做 LC，很多的 LC operating agreement、LC 的运作协议都是不符合法律的要求的，都是有些时候是这个有一些错误，有些时候是根本当时建 LC 的时候，客户只是觉得说我注册了，在州里面注册一张纸以后，我的 LC 就成立了，没有任何的文件去 support 它。那如果是这种情况的话，down the road 一定会出现问题的。所以你如果要是去做 LC 的话，你就要注意了，LC 的文件一定要做好，要做全。然后另外一个就是说，以 LC 来持有房产，当然我们大多数人听到的一个原因就是说有 creditor protection 的作用，因为我们刚才也讲了，在其他的几种 title 形式里面，你比如说 tenancy in common，joint tenancy，包括你 sole ownership 这些形式，obviously 都是没有任何的 creditor protection 的这样的作用。那有一些朋友，尤其在加州目前的这个情况下，很多人就觉得说，我应该把我的投资房产，尤其是如果说我要有租客的这种情况下，我应该是把我的 LC 里面的房子和我的其他的个人的资产给分割开来、割裂开来。那这里面呢，当然是双向的、双方的。一方面的话，就是说有人是要保护在 LLC 里面的房产，因为他可能个人有的时候会有一些人，像有一些客户他从事了一些他从事的是一些高危行业，你比如说contractor，建房做房屋的这个很典型的一个高危行业，经常有可能被告啊这样等等。和有纠纷。那还有比如说医生，有一些类别的医生也算是高危行业。还有其他的像你这个从事，我们有客户是搬家公司，搬家公司也是算是就是当你去买 workers comp 的时候，人家都会把你list 成为这个高危行业。如果你从事高危行业的话，你可能希望你的投资的房产本身被保护。那还有一种呢，就是说有一些人他本身，你比如说我就是一个 software engineer，我本身从事的就是也没有什么风险的工作，就是一个朝九晚五的这样的一个行业。但是我的这个投资房可能是一个 problematic 的一个 asset，因为就是有可能会被告。那我不希望在这个投资房产生的这些纠纷，那这个投资房我本身如果上面有任何的纠纷或者什么的话，那这个房子本身是没有办法的，因为你的这个 asset 就本身就是这个标的嘛。但是我不希望说，假设说我有任何的 liability 存在的话，然后我的 insurance 可能没有办法 cover，或者说insurance cover 不到的话，我不希望说我的个人的资产被牵连。可以被我的 creditor 去 reach out 到。所以说，其实 LC 就是这种起到一个双向的资产隔离的这样的作用。但是，呃，这里就是为什么就是 Michael 利律师刚才也花了一点时间去跟他讲，就是 LC 的关于它的，如果说你要是去做的话，你就要去符合它的所有的规定、所有的要求，你要真的是把它的所有的文件给做全，你要有一些 record，你要去做compliance，然后你要去真正的去 segregate 你的 asset，不能说你建了 LC 之后，你不去维护它，而是说只是说我去注册了一下，有一张州里的注册纸就行了。This is not good enough，这个是远远不够的。你一旦要做的话，要真正的去 serve 你的 creditor protection 的这样的一个 purpose 的话，你就必须得要去尊重它的 formality，虽然它没有那么严格，但是最基本的一些像 operating agreement，像你的一些这个基本的记录啊，这些的都是要有的。更何况你的 LC agreement，尤其是你跟其他的投资人一起去做投资，做投资房的话，本身也是对你和投资人之间的权利和义务的一个规定。那在 LC 的文件当中呢，彼此双方就是大家都互相之间把自己的权利义务都规定好，然后包括其实有一些情况下，比如说我们刚才讲的，在如果有人失去意识行为能力或者过世的情况下，那么在 LC 的文件里面，我们也要可能去 address 这样的一些问题，包括 LC 当中，比如说大家可能都是同样的出钱去买房的人，但是谁能？那我们知道，就是尤其是有一些 LC，它做一些翻修、整修房子，那这个在整个整修翻修这房子当中，可能太多的问题了。那到底谁有权利来去做这个决定？谁是 LC 的 manager？manager 的话，他有哪些的权利和义务？其实呢，都是需要在这个LC 的文件当中，你需要去把它规定清楚的。只有你做好了。做完整了，做好了这些文件，那你的这个 LC 才能真正的去起到了你想要的起到的这样的一些作用。那另外呢，就是 LC 在这里面还有一个就是好处，尤其是你如果当时买房的时候就以 LC 的形式来去购买，那在我们知道大前年吧，pass 了这个 Property 19，19号地税法案，19号地税法案之后呢，以 LC 购买房产，在一定程度上，在继承的时候，就是假设说有夫妻，如果是夫妻两个人这种情况，举个例子啊，然后如果去世的话，出现继承的这种情况下，在一定的安排下， 可以避免地税被重新的评估。因为在19号地税法案通过之后，我们大家知道的是，基本上所有的投资房在小孩子女继承的时候，它的地税都会被重新的评估。但是呢，有一种形式去持有投资房，但是这种必须得是你当时买房的时候，买投资房的时候，就直接是以 LC 的这种形式来去购买才可能达到的啊。如果说你现在已经以个人的名义去购买，然后现在想转进去的话，这个是非常难去实现的。就有一些安排的话，可能会有一些 tax 方面的一些 property tax 方面的一些advantage 可以去实现。我不知道 Michael 在这方面还有，我们时间也有限，time is a little limited. So do you have a couple of points you want to add on this?
Really just this with regard to using the LLC for asset protection, for tax advantages, for all of these things is like anything, the devil is in the details. And $100 piece of paper that you mail to Sacramento and say, tell me I'm an LLC. And they say, sure, you got $100 and $800 a year thereafter. Sure, you're an LLC. Why not? Send us the money. That piece of paper is not going to protect you for asset protection or for tax advantages if you just have that piece of paper and some hokey downloaded operating agreement that doesn't make any sense, or it's from another state or is generic that doesn't match California law. The LLC has to be a real thing. It has to keep appropriate records. It has to be structured right. It has to be, there has to be appropriate minutes that you actually followed the business formalities and treated this thing like a business. In a way, what is this for? Is that the records are good enough that if I were to sell the LLC, which a lot of people do, not the real estate, that a buyer would look at the records and feel comfortable buying that. That it is well structured. What do I look at as a good case for this? The case is the Ocean Avenue case. This is a great Prop 19. It's a pre-Prop 19 case. It's way before Prop 19. But it is a case on fractional ownership purchasing. And it kind of answers the question of why did Michael Dell, his wife, and for some reason his wife's brother, buy the Santa Monica Fairmont together? Usually you don't have your brother-in-law in there if you're Michael Dell. The reason is because the original owners had it in this kind of odd 40-40-20 split. And you can, if you create an LLC, let's say husband and wife or more people, and you have it divided, and then you have 2 or more children, and the original division, husband 50%, wife 50%, then go to son 50%, daughter 50%, and it has to go very specifically. Husband's 50% must be not community property. You have to do a document regarding that, and it must go to son only. The same way daughter, the wife share, that must not be community property, document for that, and that must only go by specific distribution to daughter because you can never cross the 50-50 threshold. And the LLC has to be the original acquirer of the property. If you do that, and the properties go through the LLC on and on and on and on, you'll never get a reassessment as long as it stays divided between the families. So this has to be done properly. The counties are not just going to take some $100 thing from Sacramento, and yeah, the records are kind of all over the place.
It is $70, Michael.
Oh yeah, $70. Yeah, I'm thinking corporations $100. So yeah, they're definitely not going to give it to you with the $30 discount. And say, yeah, I don't want to pay taxes. They're going to make you pay taxes. So
there was a period of time it's for free.
Yeah, during COVID.
Yeah.
And I'll just finish my point on this is that you have to, especially if you're doing the proposition, you're trying to advantage and avoid the Prop 19 situation on newly purchased real property, you have to set that up meticulously correctly because the counties want to reassess that property. Why? Because that is a permanent, forever tax increase as soon as they're able to reassess. And any mistake, like we just said half and half go to the son and daughter. oh, half and half was a community property to begin with, and then to son and daughter, and it was, share and share alike. Nope, that's not separate shares. That was all one share community property. And then it went half and half. It went 25, in a way, 25%, 25%. And then when his wife passed 25, 25. No, that doesn't match the separate, that doesn't look like Ocean Avenue at all. They're right, doesn't. You would reassess tax for that. You'd use the cumulative rule. But if you created the LLC also with a transmutation agreement, you separated this all. It was husband share, wife share, son's side, daughter side, and it was a specific call in the trust. Then you're good. But you got to document this meticulously because the other side does not want to agree. In fact, it's their job not to agree. The same way, a creditor, if I drove over somebody with my car and they say, I got this thing that says a $70 stamp from Sacramento, don't take my stuff. Yeah, you drove over somebody with their car, they're going to try to take your stuff. You better be pretty thorough about that this was a real business entity. Oh, one other thing that we didn't mention, actually, sorry, that actually is a bigger problem that came up just because we're running short on time. LLCs or the multiple title holding. I'm dealing with a case that's a real headache on this. The person came in for their trust and they said, oh, yes, I own 4 of these properties, or these are all my properties. I want 5% to Jim and 10% to Susan and 11% to them, and then this to this to them. And we looked at we said, okay, we could do all of that. We looked at the properties. The property titles are all over the place. Some are joint with her son. Some are with the son and the son's partner. She's not on title at all. Some are with like a friend, and some are joint with the friend. So it's all over the place. And this is just another rule to put a major, 50 stars by this one. You can't convey, as in sell or control, you can't testamentally devise or place into trust things you don't own. So if you are buying properties with friends and you're kind of doing different things with titles where you say, well, my brother got a good rate because he's W-2, and so we used his name on the property, but it's really my property, it's all of my money. The law says it's the other guy's. So you need to start thinking that through now, because these off-book agreements cause a real mess if you don't think through.
Yeah, actually, Michael, I have a real example just recently， 就是我现在也在处理一个案子，就是大家在买房的时候，可能更多的买投资房的时候，可能更多的考虑的是一些非常就是现实的一些问题，比如说贷款的，刚才 Michael 也提到了就是比如说贷款的问题，比如说谁可能这个在家里面可能更多的就是一个大家族里面去 manage 去管这个资产的问题，所以说当时在买房的时候，可能就没有去做一些 title 的 planning。所以在持有这个房子的时候，就经常会做一些可能在我们看来现在就是根本就没有办法去弥补的一些问题，因为我们现在在处理的有的 case 就是 OK， 当时在买房的时候大家都很 happy， 都没有什么问题，但是现在突然爸爸这个生病，病重的很厉害。我现在的一个案例就是这个情况，父亲就是生病的很厉害。然后父亲生病很厉害的时候，这个时候大家都开始着急了，因为本身就是父亲来持有的房产，父亲和女儿的女婿，以及父亲跟其他的人去持有这些房产，但是实际上都是家庭的财产。但是如果说我们现在就不去改变 title 的话，那就会有一些问题，就是怎么在家庭的这个财产的问题当中，遗产继承这方面去实现一个平均或者公平，以及真实的去反映他们的意愿。因为当时 title 持有的这个形式的话，并没有去考虑到这些问题，但是父亲现在病重的情况下，大家都必须去面临这个问题的时候，你就要去做一些现实方面的一些考虑。但是这个时候在转换 title 的时候，在转换房子的 title 的时候，就面临着非常大的一个问题，就是说，比如说 property tax 的问题，地税会被重新评估，比如说贷款的问题，比如说就是所有的问题，比如说如果父亲去世了以后，如果说这个有一个其当中的一个小孩去持有房产，他会不会改变心意？如果改变心意，对其他的 sibling 都是非常不公平的这个情况。 所以我们其实是想跟大家传递的一个信息是说，title 房地产 title 在你一开始购买的时候，不管是自住房、投资房，就是非常非常重要的。如果说你没有很好的意见和建议，更何况我们今天还没有 touch 的一个问题，其实是 estate tax 的问题。如果说你是外国人，甚至是绿卡持有者，有一些情况下还要考虑一些这个以后的赠与和遗产税方面的一些问题，所以其实是可以是非常复杂的。大家一定要在 acquire title 的时候就把这个规划给做好，而不要就是想着说以后有一些方法可以去补救，因为有的时候你去补救的话，可能没有那么完美，会有一些你需要去就是牺牲的一些东西啊，就这里面给大家强调一下。那其实呢，那这个我们就接下来就顺着这个讲哈，就是以 LLC 来持有房产，很多人就问，那有没有什么就是我们应该去注意的这个 cons，比如说不利的一些影响，在我们看来，其实就是如果投资房产，呃呃，如果说你就是一个就是可能在加州非常 annoying 的一件事情，就是说很多人投资的是 single family house，如果是 single family house 的话，我们一般不会建议说你把就是把你的所有的 single family house 都放在一个 LLC 里面，而是说你要去建立不同的 LLC 去持有不同的房子。那你每去建一个 LLC 的话，都同样的会有这个一个刚才我们讲的一个 compliance 的问题。那最主要的，其实对于很多人来讲，可能是有一个 franchise tax，每年有800块钱的一个费用。但是我想就是说，如果说你的角度是说这个就是一个 business expense，就是你做生意的一个成本的话，那可能跟你每个月去 collect rent 相比，这800块钱可能也没有那么高。但是对于有一些客户来讲的话，他比如说他有很多很多的房产，他都是 single family house，每一个都800块钱，可能加在一起，他就会觉得是一个挺高的一个费用。所以这个就是你自己需要思考的一个问题。但是我觉得 in a nutshell，我们想给大家传递的信息是什么呢？我们会建议大家，如果说是一般的 residential properties，你如果是这个1到4个unit 的这样的房子的话，我们会recommend 大家考虑以 LLC 的形式来去持有房产。但是如果说你是一个 multi-family 的，或者是一个 commercial property 的话，在我们看来就是其实我们觉得是 essential，是非常非常必要的。你要去考虑以 LLC 来去持有房产，尤其是刚才 Michael 讲了，你一开始去购买的时候就要考虑以LLC 那这样的时候在 planning 的时候，我们还有一些 property tax 的一些 planning 的一些 opportunity 啊。OK，那我们接下来呢就 move on 到，我们想给大家就是简单的说一下哈，用大概5分钟的时间，先讲一下在房地产上你可能你要考虑有哪些税务的问题。那首先就是地税，地税刚才我们已经简单的跟大家介绍了一下，就包括 Property 19以后，你的地税方面的一些变化啊这一些的。那如果是出租房的话，一般来讲就是 investment property，在子女继承你的房产的时候，一般就会失去你当时买房的property tax 的税基。那这个时候呢，就会美婷，我想你要换下一个 slide。Yeah，所以这个时候呢，可能很多的出租房的房产就变成一个不是特别 attractive 的房产。如果说税基被重新 reassess，嗯所以这个就是你这个可能我们必须要考虑的一个问题哈。另外一个就是在你的 lifetime 当中，如果说你做一些房产的 ownership 的改变，像有一些客户把他的房子，比如说放到举个例子，不可撤销信托里面，可能就面临这样的问题，他的房产会要房产税会被重新评估。那这个时候呢，就要去做一些具体的分析，那到底这种情况下是不是值当，是不是合适去做这个事情？那另外的2个税呢，都是跟一个是 income tax，一个是 capital gain tax。那都是 income tax，当然就是说跟你的如果你出租有房租收入啊这些的话，那这个部分呢是需要缴税的。 那另外呢，capital gain tax 就是你当然卖房的时候你需要去缴税。那如果是 gift tax estate tax 呢，就是说你如果将房子赠与出去，或者说你在过世的时候，如果说你超出了遗产税和赠与税的免税额度的时候，你有付税的义务。那我们请 Michael 律师简单的给大家介绍一下，在这几个方面，它有，因为我们也列出来了，比如说在 income tax 的角度来讲，可能房屋是一个相对来讲比较好的一个呃资产去 collect 收入 compare to 一些其他的一些 income。那 capital gain tax 相信有一些朋友也非常关心，也会问我们，比如说用 CRT charitable remainder trust 或者是103E exchange 啊这样的一些方式去做一些 capital gain tax planning。能给我们就简单的说一下这个情况吗？Michael, yeah, can you just comment on these taxes?
Oh, well, with all these, one of the things to think about, I think we're generally familiar generally with these kinds of taxes. The thing to think about is how do different entities, business entities, change some of these things, and can be um, uh, a bit of a problem. So generally, why we often think of LLCs for real estate is because LLCs generally are taxed as a Form 1065 partnership. So partnerships are pass-through entities, so that when you contribute the property to the LLC, the tax attributes essentially pass through, and it's a look-through entity as to the taxes. Be careful, and I see this every once in a while, and I'm very, very cautious, and sometimes a little bit nervous on this, is that on these things, if you use an S corporation, so on an S corporation, you can have problems if the S corporation gets converted to a C. So be careful on if you use entities other than an LLC, and I really, really, really don't recommend it. Like an S corporation, is because you have to be extremely certain that when you formed the corporation and then applied for the S designation, you have records that you applied for it, and then you have records that it was granted. Because when you form an LLC and you get the EIN, even if you select the thing that says S corporation, until you actually file the, usually by fax, the check the box regulation to become an S corporation, that thing for the EIN does not automatically make it an S corporation. It's a C, and holding real estate in a C corporation is really a disaster in almost all situations. So be careful of that. Income tax, this is just going on that, some benefits of trust. The step up in basis resets the basis for the property and eliminates depreciation recapture. So that can be very attractive when designing the estate, is that if you got property that you had a low basis, you've depreciated all of the basis out, and then now there's going to be depreciation recapture if you sell it. Hold it. Try to hold that property as long as possible. Allow it to pass to your loved ones by the inheritance, and by that there will be the step up in basis. And then you can depreciate again. CRT, we've talked about this one quite a bit. For the CRT, is that one will have quite a significant benefit to stretch out and reduce capital gains taxes. So if you don't really like 1031 exchange, you don't like qualified opportunity zones, you want the stream of income, but you do want to sell the asset, charitable remainder trust is good. And then the last thing that I'll talk about is estate gift taxes. Gift taxes. If you've done significant gifts for estate planning purposes, usually the initial gift, if it is over the annual exclusion, I recommend, well, if you're over the annual exclusion, I don't recommend. The IRS tells you, you file a return. It's not me recommending it. The IRS says you have to file a return if it's over the annual exclusion.
And the annual exclusion this year is $18,000.
Yes.
就是现在的那个每年可以每个人免算终身免税额的，给任何一个人18000美金的 asset during lifetime.
Yes. So for that, you of course you have to be aware of that number. So with that, for the gift taxes, if you've gone over that, you're required to file a gift tax return. A lot of people say, I don't want to do that. You want to do that. Why do you want to do that? If you're doing gifting to get it out of your estate, and you want to get it out of your estate because you're doing an ILIT, an IDGT, you're just giving it to your grandchild just because I'm just going to give it to them. You want to file the gift tax return, because if you file the gift tax return and you substantially disclose, you disclose what the gift was. You tell the IRS, I gave them 10 gold Krugerrands. The spot price was $2,300. Here's the thing from, the report from the day that I transferred it over. Here's a receipt signed by, my grandson, who's over 18, that he got the 10 gold Krugerrands, and I file this return. It sets the wheels in motion for the IRS to object. Let's say that Krugerrand example, it's very well disclosed. There's no problem. 3 years goes by, it's over. Statute of limitations ends, and the IRS can't come back and say, wait a minute, that wasn't the right thing. The Krugerrand's an easy one. What about things like ILITs or IDGTs? File the return. Disclose that you did it. I even sometimes recommend for clients that do under the exemption, I say for the first year, file the gift tax return. Let's just tell the IRS we did this. Let's get it out in the open. Ironically, with the IRS, disclosure is key. Saying, I told you 20 years ago that I did this ILIT. I told you I did all these gifts, and you never said anything. And then later, I passed away. It was my kids saying it. And then later, you coming back and you say that was part of the gross estate. No. I told you 20 years ago. I told you 50 years ago. Your time to complain about that was then. That's a that's a winning argument for estate lawyers. We love to, for people who do estate tax work, we love to see the filed tax returns. It's when it was kept a secret, we have a big problem. So then the IRS says, they never told me about this. It was all a sham. It's all a secret. They kept it a secret because they controlled the island, they controlled the IDGT, they controlled all of this. And the reason why nothing was filed was because it was all false. It all belongs in the gross estate. So thing is, file the return. You say, uh-oh, Mike, I haven't filed the return for the gift tax thing. It's late. It's in fact, it's been a few years since I did the gift. Aren't I going to be subject to penalties and all these things? I said, well, if it was a few years, did you gift over $12 million? I say, no, it's like $100,000. Penalties relate to the amount of tax owed. And on that informational return, unless you gifted more than $12 million or whatever the lifetime exemption was at the time, there's no gift tax. So there is no penalty. And you are permitted to file late gift tax returns. So you can substantially disclose. Filing them late is no problem. Filing them timely is better. But if you forgot to do it and they've kind of stacked up, I recommend file them. Just get them on file. No problem. There's no penalty. There's nothing wrong there. They're late, but that's that you can still substantially disclose. The IRS likes disclosure, no problem. And then the other thing that I really have to stress on the gift tax return and the estate tax return, I'm dealing with this now with an estate tax return, particularly the estate tax return. Again, this is more for your relatives, friends, relatives and friends on this one. Don't skimp on the estate tax return and hire somebody like a CPA. And I love the CPAs, but don't hire the CPA who says, yeah, I can do it. And they say, how many have you done? Well, after this one. Don't do that. You file this once in your lifetime. And if you're filing it, this thing is pretty darn important. And I have somebody that was doing one a few years ago, and now they're up for examination because there was a problem with how they attached the schedules, and it just kind of got all confused. So like on these things, do invest a little bit of time and effort and work on the estate tax return, because again, you only do it once, and if you try to skimp on this thing, and because it's a once in a lifetime, very important return, and you're likely doing it because there's some significant value you're trying to predict. You got to do it right, and critically, estate tax returns cannot be amended. There is no amendment of an estate tax return. There is once in a lifetime, one shot. The only thing you can do is, if you do it wrong, is you can send supplemental information, but that's it. So just be aware of those, is that they're not like income tax returns, and even amending income tax returns really kind of iffy. But for estate gift, there's a one shot thing.
OK，因为时间的原因啊，我们现在先到最后那个这个，因为我知道很多朋友就是这个可能要下线，所以我们先分享一下我们下一次的讲座，要讲的内容。下一次讲座我们会讲的是，如果我们用这个信托，如何在信托里面为我们以后如果说假设有失去意识行为能力或者失去身体机能方面的一些受损的这样的一些情况，如何去做 plan。particular 我想说的是，就是我们现在在 plan 当中遇到越来越多的，就是有一些朋友可能因为年纪越来越大，可能会有比如说老年的失忆症啊、健忘症啊，甚至是更严重的老年痴呆症这样的一些情况。就是如何在我们的遗产信托当中，不仅说是 take care 我们爱的人、我们关心的人，那更重要的是，在我们有生之年，假设我们出现了这样的一些情况的话，我们的遗产信托文件怎么来去保护我们？所以这个是我们5月讲座的内容啊。先给大家介绍一下，然后另外就是说分享一下我们的联系方式。如果说大家有任何的问题的话，可以用这些方式联系我们，可以 email 我们，可以添加我们事务所的微信然后左边的这个就是，如果说大家想要报名5月份的讲座的话，你也可以 scan 一下我们的QR code。其实最后今天我们就把这个 screen leave 在这儿啊，所以大家如果想下线的话，你就可以下线了。但是最后呢，我们再用大概5分钟的时间，一个是稍微讲一下关于地产方面，如果说你做 estate planning 的话，需要注意的有哪几个点。然后另外一个就是我看 Q&A 里面有几个大家问的问题，我们也给大家答一下啊。一个是就是在房地产做 estate plan，它一个比较特殊的一个点，就是说这个我们都知道，它就是不是一个特别 liquid 的 asset，不是一个流动性的，不像现金或者是保险，你比如说人去世了以后就直接去赔一笔钱。那房产呢，它有它特殊的一些属性，你比如说有一些房产的话，它可能是家庭想要去继续 keep 住的，那有一些房产呢，可能是你想要去卖掉的。那就是在人去世了之后，比如说父母去世了这种情况下，一个非常重要的一个问题就是说，如果说这个房子放在这边的话，就是要做的一个决定是谁有权利来去决定这个房子到底是 keep 还是 sell。那如果说要 keep 这个房子的话，谁来去做房子的trustee manager 来去 manage 这些房子？那以及如果说你有这个，比如说，如果你有一个小孩呢，可能比较好办一点。但是如果你有 multiple beneficiaries，有 more than one child 的这种情况，那如果大家都想要这个房子，那怎么来去分割？那如果说可能2个或者2个以上的人，以上的这个继承人在房产上，那可能会有一些问题。有一些 challenge 呢，比如说大家如果关系本身也不是特别和谐，那会可能并不太适合去一起去持有房产，那可能更多的就是变现，变现了之后呢，以现金的形式来去分割资产可能更好。所以就是在房产的 estate planning 当中，其实有很多很多的一些问题，还有就是刚才我们其实也涉及到了房产会涉及到地税一些非常微妙的一些地税的一些问题。那如果说尤其是像地税这样的税被重新评估之后，那可能尤其在我们湾区，这个房子可能并不是一个特别适合去做投资的这样的一个房产，这些都是你需要在做这些规划当中可能需要去考虑的。所以就是给大家提示一下，有这些问题需要考虑，就是你自己可以去思考一下。 那如果有具体的问题呢，当然也可以问我们啊。那在 Q&A 里面呢，有2个朋友不约而同的问了同样一个问题，这也是我们的客户当中就是遇到的最多的一个问题，就是说如果说有贷款这种情况的话，你的房子是不是还是可以去把它变成 LC？答案是不可以。如果有贷款的话，就是其实我不应该说不可以，是说你必须得要跟你的 lender 去商量。如果说你要去做这件事情，就是最好的方式就是你在购买的时候就先把 LC set up 好，直接以 LC 来去。就是 LC 也可以去贷款嘛，只是说可能有一些特殊的要求，有一些人不一定符合呀，这样等等。但是，一旦你是以个人的名义来去持有的，然后现在你要把它然后这个房子现在有贷款在什么有 mortgage 在上面的话，你如果要把它放到 LC 的话，你必须得要征求 lender 的同意，否则你不可以就是自己就把它做到一个 LC 里面。那相反的是什么呢？如果说你的房子有贷款，你是完全可以把这个房子放到一个 revocable living trust，放到信托里是没有任何的问题的。原因是什么呢？就是因为在法条里面有特殊的关于信托的可撤销生前信托的规定。所以你房子有贷款也可以放到信托里面，但是房子有贷款的话，如果要放到 LC 里呢，就必须得要经过 lender 的同意才可以啊。所以这里面给大家解释一下这个问题，因为有2个朋友都在问这个问题。那另外呢，有的朋友问说，就是关于房子，如果说是把它转到 partnership，这个需要怎么转？一般来讲的话，如果是房子要把它放到比如说 LC 或者 partnership 这样，但 partnership 现在不是特别常见了，主要是 LC。如果放到这样的 entity 当中，都需要去 record deed，而不是直接就是说去 record 这个 assignment。这位朋友提到了这个 assignment，因为如果你以 LC 来去持有房屋的话，你持有的并不是房屋本身的产权，而是 LC 的 membership interest，然后 LC 再去持有这个房子。那你在做遗产信托的时候，一般来讲的话，你要对你的 LC的 membership interest 去做规划，然后可能是通过 assignment 的形式。但是呢，在这个房子的 title 上面呢，实际上持有的 title 要由这个 LC 来去持有，一般是这样的一个逻辑关系。所以要去 record 什么呢？其实是去 record 你的这个房屋从你的个人的名字变到 LC 的名字。像 Michael 刚才讲的，就是说这个 title 还有一些讲究，就是怎么去写啊，这个。但是一般来讲，我们要去 record 的不是这个 assignment 本身，而是要去 record 这个title，要把这个房子的 title 真正的在 county 那边变成是LC 的啊。OK，然后我们的还有这个朋友就是有一个 follow up 的问题是，如果放到 trust 里面，还能把有些贷款的房子和个人分开吗？我不太理解他的这个意思啊，就是说一般来讲的话，就是呃。就是如果说您问的是，从资产保护的角度来讲的话，一般的 revocable living trust 是没有资产保护的作用的。如果说你这个我也可能理解错了，但如果您问的是这个问题的话是这样。然后，制作这个 LC 的整个的过程，并不需要很长的时间，一般一周下来的话，应该就是可以做出来。但是有的时候会有我们遇到的非常复杂的一些情况呢，是如果投资人特别多的话，大家之间要去商讨彼此之间的权利义务。如果有这种情况的话，可能要花更长的时间。那我们今天讲座的 recording 呢，是会放到 YouTube 上，大家如果搜我们的名字是可以看到的。如果说您找不到我们的话，你也可以联系我们，通过这些方式联系我们，我们可以跟您讲一下怎么能看到我们的 recording。OK，好的，那非常感谢大家今天晚上来参加我们的讲座。那我们就在下个月5月29号的时候，周三的晚上再和大家相聚。也感谢 Michael 今天晚上的精彩的演讲。好，祝大家晚安。
Good night.